This is Rue Ziegler, January 6, 2009. I'm interviewing Mervin Lernhart, and this is tape number 2 at Mervin Lernhart's offices. And Mervin, you were just talking about the Assembly Bill number 80.
Yeah, what I was saying is that my recollection is that the impact of Assembly Bill 80, which required assessment based on comparable sales, really resulted in a lot of pressure to convert agricultural land to for development. And the reason for that is if you can envision urban development, or usually subdivisions or similar type of residential development along the periphery of agricultural land, then that land becomes the basis for the comparable sales for the agricultural land. Now the agricultural land, when I say along the periphery, along the edge of it, the farther away you get into the heart of the agricultural land, the less, at some point, the effect of that, those comparable sales for development purposes tapers off.
Yes.
But in terms of the land that's assessed based on those comparable sales outside of the agricultural land for the purposes of development, they resulted in the agricultural land in effect being assessed as though it were development land. That assessed value resulted in an increased taxation. So now the farmer is farming. I'm saying farmer, but it could be a vintner or whatever.
Yes.
Anyway, the agrarian is working his land, but he's paying taxes as though it were development land. And that resulted in an increase in tax burden on the agrarian land. And it also, so it contributed to an incentive to sell to the developer, because you're getting taxed for it anyway.
Something that wasn't anticipated, I assume.
I don't think that was anticipated. And then along came the Williamson Act shortly after that. Now, I don't recall the full name of the Williamson Act, but I remember it as the Williamson Act.
The full name, it was passed in 1965, and it was called the California Land Conservation Act.
Okay. Under the Williamson Act, as I remember it, and this is kind of a summary of it, but what the Williamson Act allowed for was the farmer to agree to maintain his land for agricultural purposes for a certain term. In return for that, his land was then assessed based on capitalized agricultural income rather than on comparable sales. So the Williamson Act was, according to my understanding, directed at relieving the pressure on the agricultural land that AB 80 had created as kind of an unintended consequence.
I see.
So the idea then was that the property owner could agree to these terms, and if he agreed to keep his land for, I think it was for a certain number of years, then he would be assessed based on capitalized agricultural income rather than comparable sales.
I think that was for just 10 years.
Yeah, it was more than just a year or two, but that sounds right. I don't really remember though.
And it then allowed individual farmers or agrarianists to have some tax protection, but not in any collective way in terms of the land.
Well,
like
yeah, I think I'm not certain of this, but my recollection is that one of the problems was that I think the Williamson Act required that an agreement to use the land for agricultural purposes, but I don't believe it imposed a limitation on lot size or division of the land. So you have this situation. Got to fast forward with me for a moment, but I learned, uh, or came to believe anyway, that the division of the land was almost as bad as the assessment for other than agricultural purposes, because if a farmer or an agrarian were vintner, I don't think they were vintners at that point though, passed on and wanted to leave his property to his kids, he could divide it. And so supposing he divides it into 3-acre, 2-acre parcels, then you have, then the ownership becomes fragmented. And there's this concept, I was told, by the local farm, I don't remember what they were called, but they were very important to the Ag Preserve. They came down and made a lot of recommendations.
Was this the farm, not the Farm Bureau?
Yeah, like Jack somebody, I think was.
Oh, Jack Fisk?
Yeah, Jack Fisk was a consultant that was involved in that, and really an important part of the Ag Preserve, I think. So he along with other folks came up with the idea of imposing I think it was 40 acres, 40-acre minimum lot size. So that would mean that if you had less than 40, you couldn't divide it at all. And if you were going to divide it, you'd have to have 80, because 40 would be absent some sort of variance or something, would be the minimum lot size. Now, that I'm just trying to remember what Fisk and people that knew more about it, and I'm just, what I'm telling you is what I absorbed from them. I don't know much about any of this stuff, but I was told, or the basis of the Ag Preserve in part was that there was this concept of a minimum agricultural unit in terms of lot size to work the land economically or to stabilize it or whatever those sorts of concerns were. In the area that ultimately became the Ag Preserve, there was, as I understand it, there was what's called a microclimatology. And that means that the climate varies from different parts of the Ag Preserve. And also there was a variation in soil type, and different soil types are apparently, some are more suitable for agricultural use in general, and some are more suitable, I suppose, for vines. And you'd have to talk to somebody from the Farm Bureau to give you much more information than that. But this idea kind of developed that we could blend together. Well, so that was the basic setting for it. I don't know if I'm getting ahead of myself here.
No, it's very interesting.
So the idea came up that, I don't remember who initially had the idea or if it was a joint effort or what. A fellow named Carter, I think, was the planning director. I think Carter, Vern Carter.
Oh, Vern Cotter.
Cotter, yeah, Cotter, Vern Cotter, and a guy named Al Hauberger was important. He was the county manager at the time. And Jack Fisk was involved in this.
And Jack Fisk, I think, was an advisor to the Farm Bureau.
Yes, he was, and he's the one that made the soil first. He's the person that supplied, as I recall, the information regarding minimum economic units, or what would be an efficient lot size or acreage to
a viable size.
Yeah, but in terms of working the land. So anyway, the idea developed that it would be possible maybe to blend, to strengthen the Williamson Act, and to combine it in a way that the land could be, we would avoid this business of the land getting divided, which was really a weakness, I think, that the Williamson Act had at that time.
Yes, because it didn't address subdivision.
So the proposal, as I recall. The first idea was that we being the county, would make it a condition that you be in an agricultural zone that would restrict lot size, limit lot size, restrict lot size to certain. I don't want to say restrict, it's the opposite. Would limit lots to a certain acreage, say 40 acres or more. That's my recollection. It could be less or it could be more. It could have been 20, but I think it was 40. But maybe I'm thinking of 40 acres.
No, I think it started out as 40,
Yeah,
got reduced to 20, and then went later back up to 40.
Yeah, I think that.
But it started out as 40.
Okay, so with this 40 acres, that's how the 40 acres came about. So what the idea was that the county would create an agricultural zone, and in order to take advantage of the Williamson Act, you'd have to be in that agricultural zone. So it was kind of a carrot and a stick in a way. Now, if you agreed to be in that agricultural zone, you couldn't, as I said, you couldn't divide the minimum lot size was initially 40 acres, I think. So then the only thing really left, I mean, with that rudimentary idea in place, was what land should be included in this so-called, I don't even know if we called it an ag preserve at that time, but in this idea, this agricultural land that was going to be combined with the Williamson Act. And that's where Fisk, and I'm sure there were other people involved in it, got involved, and they looked at the soil type, and they looked at the microclimatology, and I guess they probably looked at historic land use and so forth. And so a large geographic area was identified, and after some refinement, that became the ag preserve, and that had various, it certainly had other conditions in it for zoning conditions, land use conditions, and so forth. But essentially, what I've just said is my recollection of how it came about. There were other thoughts about it too that were kind of interesting.
Yeah?
Yeah, because urban intrusions into agricultural area, even the intrusion into it, supposing you have land that is not suitable for agricultural use because of soil type or something else. My recollection is that we had information that the urban use to some extent could be incompatible with the agricultural use, depending on traffic and all kinds of things, like, or perhaps the agricultural could be inconsistent with the urban because of spraying and agricultural type of activities. So there was an idea to not only limit the lot size, but to exclude from the preserve itself other uses. Now, that wasn't totally true. There's knolls there in the outcropping in the valley. As you go down, you'll see knolls.
Yes.
And they're generally rocky, and they're generally not suitable, my understanding is not suitable for agriculture. All of them aren't, anyway. And there was some thought about what to do with those knolls. And I don't know whatever happened with the knolls, to tell you the truth. But I know some were included for the integrity of the preserve, even though those knolls themselves weren't prime agricultural land. Now, to give you an example of some of the things that might have been thought about, or people might still be thinking about, if those knolls could be zoned for residential use, then you would have this, I think, what would be highly desirable property. You'd have houses on a knoll surrounded by a kind of a sea of vineyard. Be very attractive property. And I suppose you could have spun that off in a way have something called, I think it was called cluster zoning, where the yards are minimal. And then there's a lot of things that could happen. The owners could have an interest in the vineyards surrounding it, for tax advantages and so forth. But I'm not sure any of that. I don't remember whether that was for another day. I know we thought about those.
But those things were discussed.
Yeah.
And I wanted to ask you now, how were these ideas sort of discussed and debated? Were these in small meetings?
Yeah, I think so. What I'm talking about here are areas where it wasn't my particular area of expertise. It was Jack Fisk and the Farm Bureau and other. I think there were other consultants too. I don't recall, the names, but there were meetings to identify what land should be included and not included. There were a lot of work groups, work meetings, and that was kind of a thing that went on for a time.
And this is long before the public hearings, of course. This is just trying to air the possible ideas.
Yeah, and that's how this came about. Then when it reached the point where there were going to be public hearings, there was an area, not written in stone, but there was an idea of what was to be included. And there was also a pretty good working idea of what the limitations and restrictions and so forth of that agricultural zone would be. The primary problem was a lot division, because people didn't, if you think about it, if you've got 3 kids and this prime agricultural land, it's really a problem because you can't divide it.
Yes, that would be the most contentious issue.
Yes, that was a very contentious issue, probably the primary issue. Then I also think there were some people that wanted to, didn't want to be included because they wanted to develop the land or sell it, be able to sell it for other purposes at some point.
Anyway, it is.
Yeah, and that in some way was related, or at least in some occasions was related to the inclusion of, if you take a large enough area like the valley floor, you're going to have a lot of prime agricultural land, but some land of lesser value for agricultural purposes is inherently included in that. And then there was a question as to what should be done with that. Could it be excuse me, could it be available for use other than agricultural because it wasn't as good for agricultural purposes? And that led back to this possibility of a conflict and so forth. And I think that there was some provision that we put in there for variances or for, I think there was some safety valves. By safety valve, I mean somebody has the planning commission of the board can make an exception, that sort of thing. But I don't recall specifics on that.
Were you looking at what other counties in the United States had how they had addressed agricultural land?
I recall that. Well, especially when it looked like there was going to be litigation. I think that that the lot size that we imposed at that time was either the largest lot size or close to the largest lot size that had been imposed through zoning
in the U.S.
That's what I thought. Because the question is whether or not it's a taking too. If you excuse me, if you limit the land, well, inherent in zoning is the question of whether or not you're taking. For instance, it's easier to see this way. Supposing you want to create a wildlife preserve, and then nobody can do anything with the land except for people can enjoy it. That might be close to it taking for public purposes.
Uh-huh.
That's I don't think that was a good argument for the ag preserve, because I think maybe the idea was that the highest and best use, which is kind of buzzwords in the, was the probably for agricultural purposes.
But
So,
there were, I know that there were a number of people who opposed it,
oh,
and some must have
yes.
seen it as a sort of socialism.
Well, yeah, and taking their right to divide their land. And, the biggest thing that I recall were that people were really upset that they couldn't leave their land to their children or to, that sort of thing. And at some point in this process, there were what, I don't know what they were called, to tell you the truth, but say educational meetings there. I remember we would go to meetings, and I remember in particular going to one in St. Helena. There's a, I can't remember the name of the hall, but there's a, where I was there, I would go, and Cotter would go, and there were 3 or 4 of us, and I can't remember whether Al Haberger was there or not. Maybe Jack Fisk was there. But anyway, I recall being in St. Helena. I recall being in there's a Rutherford Grange, I think, building. And there were several of these sorts of meetings where the public could come and ask questions, and
Now, this is before the actual passage of the ordinance. This is just
yes,
to educate.
yeah, that's my
These
recollection.
are sort of public outreach meetings.
Yeah, and I remember that they were pretty heated on occasion. People weren't all. There were a number of people who weren't very happy with the idea of the ag preserve. But so these meetings were an effort to attempt to persuade them that it was in their interest to do this. Ultimately, the ag preserve was passed, and the opposition was enough, as I recall it. So it was kind of a act of political bravery for the board to adopt it, especially for the board members that represented the Upper Valley.
There was a group that was involved in the early opposition, and I guess they were the United Vintners, John Daniel and Solari,
Yeah.
and Cameron Baker, B.C. Solari.
Yes, Daniels. Is it Daniels or Danielson? I forget which.
John Daniel.
Daniel. I remember that he was very active in opposition to the ag preserve. So in any event, that's the background on it, and that's kind of what I recall about the purposes for which it was adopted, why it was adopted, and what its goal really was to do what it says, to preserve agricultural land and protect it from economic pressures that would cause the owner to sell it or have to sell it to meet the tax burden, and to restrict the lot size, and to impose zoning conditions that would, be conducive to continued agricultural use of the land. And I think that worked.
And your responsibility was to write that ordinance.
Well, I wrote the ordinance, and I was a legal advisor on it, and we wrote the ordinance. Then, after the ordinance was adopted,
and this was, for the transcriber, this was Ordinance 274, and I believe it was adopted in April of 1968.
Sounds right. I was going to say 67, but it could have been 68. But once it was adopted, this group that you mentioned, I think of Mr. Daniels, but there was a group. What was the name of it again?
The other names are B.C. Solari, Solari, initials B.C., and Cameron Baker, B.A.K.
Yeah, do they have a name for that group?
United Vintners.
Yeah. Well, in any event, the United Vintners filed a lawsuit to have the ag preserve declared unconstitutional. And
Now, was a different group from the United Farmers? They were
was it the
later.
United Farmers? What I recall, I don't recall what the name of the plaintiffs were at this time.
Oh, I think the plaintiffs, the ones who actually filed the suit, were the United Farmers, but I don't know who the individuals were.
I don't recall offhand, but I think Daniels was involved in that. I would assume he was, and probably Solari and the others. So that lawsuit was filed, and I represented the county in that lawsuit. Although I was no longer in Dan York's office because I'd left the office at that time, or around that time.
So had you started your own private practice then?
Yes, I believe so. And or I was about, I don't, I think I had, but either I had or I was about to. In any event, I remember that case well, though, because the basis of the legal attack on the Ag Reserve was that the findings of the Planning Commission didn't support the provisions of the ordinance. And findings were the legal, the factual basis in which they make findings. Like, we find that it's in the interest of the we find this is all Class A agricultural land, and there's this microclimatology, and the highest and the best use of land is for agricultural purposes, and that a lot size of 40 acres is necessary to economically develop the land to full potential. That sort of findings.
Yes.
Not those, but something similar to that. And so the local judges disqualified themselves, and I believe a judge named Judge Golden. Yeah, Judge Golden was a judge. And
this is at what level of in the court system now?
This was in the Superior Court.
Napa County Superior Court.
And the findings were of particular interest to me because I was a lawyer that advised the Planning Commission and drafted the findings. So I aside from wanting to see the Ag Preserve upheld, it would have been not good if the findings hadn't been sufficient on a personal basis. But anyway, it was kind of an interesting trial because what I remember about it was that we would go down to the city in San Francisco, and there'd be depositions, and I kind of thought of myself, as I still do, as a country lawyer, and I remember I'd be in this law firm and had a whole floor, and there'd be mergers and, kind of what I thought was heavy-duty stuff. But
and you were a very young attorney.
I was pretty young, yeah. And but one of the more interesting things about it, this is just kind of an aside, was that I don't remember how it came about, but we went to court in an airplane, and I recall we went down to the Napa airport, and there was the aircraft had a propeller in front and a propeller in the back, if I remember correctly, kind of like an old P-38 or something. In any event, the judge was there, and the court reporter was there, and the other lawyer was there, and we flew over the valley, and each of us could point out various things to the judge, and that was the purpose of that.
I see.
But that's the only time I've ever done that, and it's obviously going to be the last time I have. So, in the end, the ordinance was upheld, and that's really the last contact, the last involvement that I had in directly with the ordinance. I represented after that some individuals or some corporations that were some of the terms of the ordinance were involved. I remember representing Charles Krug in a dispute with Behringer's that tended to involve the Ag Preserve ordinance, but not Well, it tended to involve it, but it didn't change it or anything like
Yes, it was more of a side issue.
that. Yeah, and then,
Was there no appeal filed after the Superior Court case?
you know, I was thinking of that. I don't remember an appeal, but there may well have been an appeal. I didn't do the appeal, but I don't know.
Well, you're given the responsibility for successfully winning the case at the Superior Court level. In fact, you're called a legend for both writing the ordinance
I don't know
and
about
for
that.
protecting it in court.
But in any event, the judge did decide that it was okay,
And was that Judge Golden, do you think?
I think it was Judge Golden, and I think he was from, was it Yolo County? I don't remember where he was from, but he was kind of a crusty old guy.
And now, when you talked about going into San Francisco,